Right, and to take a more in-depth look at this, we're joined now by Carrie Cordero. She is the Director of National Security Studies at Georgetown University, right here in Washington. Dinah Perkempner is a spokesperson for Human Rights Watch, one of the organizations which filed the lawsuit. She joins us from New York. And Sunday Yukubaitis is president of Golden Frog, a global online services provider. He joins us from Austin, Texas. Thanks to all of you for joining us. Dana, let me start with you in New York. Human Rights Watch is one of the organizations that's joined this lawsuit against the NSA. What is the basis of the suit?
The basis of the suit is the upstream surveillance that the NSA conducts with the cooperation of telecom companies. It literally collects everything that's going through their cables, and then it searches these communications with hundreds of thousands of keywords that might be of interest to them. We're saying that's a bit too much. Most likely, our communications are being intercepted and searched, and this really harms and affects our work in trying to protect human rights around the world.
Carrie, do you believe that this lawsuit has any merit?
Well, the suit is one of several that have been brought by organizations like Dinah's over the last several years. This particular suit concerns the FISA Amendments Act of 2008, which was an amendment to our national security surveillance laws. That act has been challenged before, and one of the challenges that this suit will face, like prior suits, is the issue of standing, whether or not the plaintiffs can show that they actually have been impacted by the surveillance that they're describing.
But does the law allow for the broad sweeping up of information? I mean, what about things like probable cause? I mean, do law enforcement authorities have to, is that a requirement? You have to have probable cause before you go and seek out information?
Sure. So there's two basic legal constructs under which national security surveillance can be conducted. One is under a statutory framework, the Foreign Intelligence Surveillance Act, which is directed at targets who are here in the United States or U.S. persons wherever they are in the world. The second way that national security surveillance can be conducted lawfully is under presidential executive authority. There's something that's a concept in law that's referred to as the foreign intelligence exception to the warrant requirement. So any type of surveillance that's conducted, even for national security purposes, either has to comply with the warrant requirement or it still has to be reasonable under the Fourth Amendment. When we get into foreign intelligence surveillance, the Supreme Court has never actually ruled whether or not there is a foreign intelligence exception to the warrant requirement.
Okay, I want to get Dinah's response to that in a moment. But first, let me go to Sunday. Sunday, we heard this term earlier on being used by Dinah, upstream collection. What is upstream collection, and how does it differ from other forms of data collection?
Well, to understand upstream surveillance and collection, I think you need to understand how the internet works, and I'll try and be brief. This collection is done on the backbone, the internet backbone. The internet backbone is comprised of network switches and fiber lines run by the telecommunication providers, and this is where they exchange massive amounts of information. So the backbone is really the highway for the internet. It is not what you use at your home as your ISP. That's really the last mile, and that's the on-ramp to the internet. And that's really more the surface streets to the highway that is the backbone. So that is what comprises the backbone. So what they're doing at the backbone is they are collecting a variety of communications, it appears, emails, text messages, phone calls on the backbone, and really tapping into that. And that is problematic for a lot of reasons. But I would make the point, this is a little bit different than the PRISM program where they worked with companies such as Google and Microsoft and worked directly for more real-time communications. This is actually on a more massive scale, because when you're tapping into the backbone, you're literally tapping into almost everything and have access to everything. So that is what upstream surveillance means.
Dana, I'm going to get your response to what Carrie said earlier on. Also, the Obama administration and previous administrations, for that matter, have told us that this surveillance is necessary to keep the country safe, to prevent another terrorist attack like the one that took place on 9/11.
I think that Carrie laid out the legal bases for this kind of surveillance, but what I think is misleading is there's nothing remotely like probable cause going on here. As Sunday was describing, this is wholesale. This is a massive sweeping up of communications and then a searching not for suspects or suspicious communications that one has probable cause that some court has considered, reasonable to look for. It's a searching of anything that is more likely than not to involve communication with foreigners. And foreign intelligence can be virtually anything, any information about foreign matters. So that means that an organization like ours, which routinely conducts foreign communication with non-Americans, gets for sure its communications swept up in this massive collection and most likely searched because human rights are very closely connected to all kinds of things the NSA may be searching for that actually have nothing to do with national security or any threat to the country. So I wanted to put that in context. And then in terms of why we think this suit is important and would succeed, the problem is that the kind of surveillance that's going on is so remote from protecting real national security interests or specific targets. It's not even arguably within the ambit of the of the amendments to the FISA Act. It's well beyond. It's being searched for general search terms, addresses, contact numbers, emails. Your communications are most likely being intercepted as well. And again, for no particular reason other than that they may implicate foreign communications.
Carrie?
Sure. So under the FISA Amendments Act and the procedures that the NSA has to abide by, even when they're doing this type of collection, which is the more broad type of collection, there still has to be a foreign intelligence purpose to the collection that they're doing. And so there is a distinction, first of all, in terms of the purpose for which they're doing the collection, and then the manner in which the information collected is actually looked at, used, disseminated for national security purposes, sort of used in any type of way. Right. And so there's a big distinction between the standards internally, which are standards that are approved by the Attorney General, standards that are approved by the Director of National Intelligence, under the activity that occurs under the FISA court, activities that are approved by the Foreign Intelligence Surveillance Court. All of that has to have a valid foreign intelligence purpose. So it's not just any type of information.
But I think the key thing you said there was the NSA has to abide by these laws. The question is the NSA abiding by these laws?
So unlike many countries of the world, the United States actually has a highly regulated manner in which foreign intelligence collection is done. And we have the involvement of all three branches of government. So we have a statutory framework, the FISA Act, that governs how procedures are done. We have a foreign intelligence surveillance court that for collections done against individuals are approved on a probable cause basis.
But you say, all of this is monitored. When Senator Ron Wyden, who's a senator from Oregon, told us that he didn't know that the warrantless wiretapping was going on back in 2001. In 2005, he said he didn't know about this. He wasn't informed by the Bush administration. This is a member of the Intelligence Committee on the Senate. So there was no monitoring going on.
Well, I can't speak to what Senator Wyden was briefed on and wasn't briefed on. I can tell you with confidence that activities that are conducted under the FISA Amendments Act of 2008, this legislative adjustment that was made in 2008, are fully informed to the intelligence committees, as well as oversight by the Foreign Intelligence Surveillance Court, these independent federal judges, as well as other executive branch oversight functions. Okay.
Sunday, I want to get to this very quickly, and that is, technically, how is this done, this sweeping up of information from the backbone, as you were pointing out? Does it mean that major internet providers are cooperating with the NSA in getting this information?
Yes, it does mean that they are cooperating with the administration and the agencies on these efforts. They're, really how it works, from what I understand, a lot is classified. I'm basing this off some of the Snowden documents and what's out there publicly. But what they're doing technically is they are installing gear inside the data centers of these telecom providers who have not put up a good enough fight, in my opinion. And they are splitting. The first step you really do is you split the data, and they basically duplicate the data, right? And so that's actually not that hard to do. And then what they do next is they have a piece of hardware, likely from the NSA, that basically filters the data. It examines the data using deep packet inspection. I used the real-world example of, they can identify encrypted packets, things that are encrypted. Well, we can, in a real-world example, you can identify an armored truck going down the highway, right? That's something that looks like, hey, that's interesting. Let me filter that. So they look at the data and try to make decisions about what types of data it is, and they filter it. And the next step they really do is then they analyze it, right? And then they try to, figure out what they can learn from it. And then finally, one of the more problematic things is they store it, and that's for a good period of time. So we don't know how long that is, and do they just analyze it later? So it is really just being sucked up and stored for years.
Okay, we are going to have to take a break right now. We will continue our discussion on the NSA and the controversy surrounding it in just a few minutes. Stay with us. You're watching The Heat.